Hi everyone, welcome back. We've got a brand new story to share with you, so let's begin. My name is Charles. When my wife's lawyer tried to paint me as the worst father in the world during our son's custody hearing, he and my wife had no idea what would come next. I watched my wife's face as she agreed with every word her lawyer said. She genuinely believed she was about to walk out of that courtroom with full custody of our 8-year-old son, Ben. What she didn't know was that I had been planning for this exact scenario since Ben turned 5, and they were about to be surprised. But let me back up and tell you how we got to that courtroom in the first place. Lauren and I had been married for 10 years, and for most of those years, we fought constantly. This was not the kind of healthy disagreements that couples work through, but real fights about money, about my job, and about the future she thought she deserved. She would tell me regularly that I couldn't provide the quality of life she wanted, that her friends' husbands made more money, drove nicer cars, and took their families on better vacations. I worked as a transmission specialist at an auto repair shop on the south side of town. It wasn't the most high-paying, but it was steady. I brought home a significant amount a year after taxes, which in our small Ohio town was enough to cover rent on our 2-bedroom apartment, groceries, utilities, and a little left over. Lauren saw it differently. She saw the grease under my fingernails and the uniform with my name stitched on the pocket, and she was embarrassed. The fighting got worse after our son, Ben, started school. Lauren would point out other fathers at school events and make comments about how different our lives could be. She started going out more with her girlfriends, staying out later, coming home with stories about the men they met at various bars and restaurants around town. At one point, we had a very heated argument when I told her I wouldn't accept her disrespect any longer. She told me she had met someone else, a man who worked in commercial real estate and could give her the life she deserved, she said. She filed for divorce 2 weeks later. Since we were renting our apartment and I didn't have significant assets, there wasn't much to fight over financially. Our savings account had about $9,000. We didn't own a house, and my 10-year-old Honda Civic wasn't exactly a prize worth battling over in court. But I knew Lauren would fight hard for full custody of our son, Ben. The problem was she had a point about my involvement in Ben's life up until that moment. For the first 5 years of Ben's life, I had been working 60-hour weeks, sometimes more. I would leave for work at 7 in the morning and often didn't get home until after 7 at night. Lauren handled all the school drop-offs, pickups, parent-teacher conferences, doctor's appointments, and bedtime routines. I was the weekend dad who played catch in the backyard and took Ben to the movies, but Lauren was the one managing his daily life. I realized around Ben's 5th birthday that this arrangement left me vulnerable. If Lauren ever decided to leave, any family court judge would look at our situation and see an involved mother and an absent father. The writing was on the wall, even before she met her new man. Our marriage was deteriorating, and I needed to protect my relationship with my son. So I made a decision that probably saved my chance at joint custody. I went to my boss and asked to cut back to 40 hours a week. My boss wasn't happy about it because I was one of his most experienced guys, but he agreed. This meant about $8,000 less per year, which Lauren immediately noticed and complained about. She accused me of getting lazy, of not caring about providing for our family. She couldn't understand why I would voluntarily make less money when she was already unhappy with our financial situation. I never told her the real reason because I didn't want to start a fight about divorce when we weren't there yet, and I didn't want her to become more careful about how she treated me if she knew I was documenting things. With my free time, I began picking Ben up from school every day at 3:15. His teacher got used to seeing me in the pickup line instead of Lauren. I started attending every parent-teacher conference, every school play, every class party that needed parent volunteers. When Ben caught strep throat, I was the one who took him to the doctor's office and sat with him during the appointment. I kept every piece of paper, every permission slip I signed, every report card conference confirmation, every doctor's visit summary that listed me as the accompanying parent. I took photos of Ben and me at school events, at his baseball games, and during homework time at our kitchen table. Not obvious documentation photos, just the normal pictures any parent would take, but I was deliberate about making sure the dates and times were preserved. Lauren noticed the change, but interpreted it differently from what I intended. She assumed I was finally stepping up as a father, because she had been criticizing me about it for years. She actually seemed pleased at first that I was more involved, and it took some of the pressure off her daily routine. What she didn't realize was that I was building a legal case for shared custody. The documentation process became second nature after the first few months. When Ben had his annual medical checkup, I was there. When he needed to get his eyes checked because his teacher noticed him squinting at the board, I took him to the optometrist and stayed for the entire appointment. When the school nurse called because Ben had fallen on the playground and scraped his knee, I was the parent who left work to pick him up. I also started building relationships with the people in Ben's life. His teacher knew me by name and would update me on Ben's progress during pickup. The coach, who ran Ben's Little League team, knew I was at every practice and every game. His doctor's office had my work number as the primary contact, and I was the parent they called when Ben needed his 7-year-old vaccinations. By the time Lauren filed for divorce years later, I had been Ben's primary daily caretaker for over 2 years. Lauren was still involved, of course, but the roles had essentially reversed from the early years of his life. She had started working part-time at a boutique downtown and was spending more time with her new social circle, which gave me even more opportunities to be the consistent parent in Ben's routine. The one thing Lauren's lawyer brought up in court that really stung was my absence from my mother-in-law's funeral. Lauren's mother, who had died suddenly of a heart attack some years back. The funeral was scheduled on a workday. I had to make a choice that I knew would look bad, but I felt was necessary at the time. Lauren was obviously going to be at the funeral dealing with family and arrangements. Ben was 7 years old and had never been to a funeral. Lauren's mother had been sick for several months before she died, and honestly, Ben barely knew her because Lauren didn't have a close relationship with her own mother. I knew Lauren would be hurt and angry, and I knew it would look bad to her family, but I prioritized my work over appearances. I wasn't even on good terms with Lauren and her mother because of their disrespect. Lauren never forgave me for that choice, calling me selfish and unreliable. During the divorce and custody hearing, Lauren had hired one of the more expensive family law attorneys in town. I found a newer lawyer who charged reasonable rates, but had good reviews from other fathers who had gone through custody battles. My lawyer was practical and direct, and she understood my strategy of letting the evidence speak for itself rather than making emotional arguments. The night before the hearing, I went through my documentation one more time. School involvement, medical appointments, extracurricular activities, and character references. My son's teacher had written a letter stating that I had been Ben's primary pickup parent for over 3 years and had never missed a parent-teacher conference. I had photos showing Ben and me at school events, baseball games, camping trips, and regular activities around town. I also had Ben's report cards and progress reports, which showed consistent improvement in his grades and behavior during the period when I had become his primary daily caretaker. Walking into that courtroom on that day, I felt nervous but prepared. Lauren was sitting with her lawyer at the petitioner's table, looking confident. She had clearly been told by her attorney that fathers rarely get 50-50 custody, especially when the mother has been the primary caretaker for most of the child's life. Her case was built on the assumption that I was an absent, unreliable father who prioritized work over family. The judge called the case, and Lauren's lawyer made his opening statement. He painted a picture of a hard-working mother who had been essentially raising Ben alone while her husband disappeared into his work. He emphasized my blue-collar job, making it sound like being a mechanic somehow made me less capable as a father. He brought up the funeral incident as evidence of my poor judgment and lack of commitment to family obligations. When he said those words about me being a low-level mechanic with a history of disappearing, I felt my face burn with embarrassment. Everyone in that courtroom heard him dismiss my profession and my character. Lauren was nodding along, clearly satisfied with how her lawyer was presenting the case. She genuinely believed that this narrative would convince the judge to give her full custody. Then my lawyer stood up for my side. She didn't make emotional appeals or attack Lauren's character. Instead, she asked the judge's permission to present evidence of my involvement in Ben's life over the past 3 years. She opened with the school documentation, showing that I had been the primary pickup parent. She presented my son's teacher's letter. I watched Lauren's face change as my lawyer presented the medical records and appointments over 2 years, all with my name as the accompanying parent. The character references were particularly effective. My lawyer presented the photos, showing a clear pattern of father-son activities over the past 3 years. They were the natural documentation of an involved parent. Lauren's confidence was completely gone by this point. She kept whispering urgently to her lawyer, clearly shocked by the evidence that I had been systematically documenting my involvement in Ben's life. Her lawyer tried to redirect by arguing that my increased involvement was recent and opportunistic, that I had only started being a good father when I sensed the marriage was in trouble. My lawyer was ready for this argument. She pointed out that my transition to being Ben's primary daily caretaker had begun over 2 years before Lauren filed for divorce. The timeline showed a consistent, long-term commitment rather than last-minute opportunism. She also noted that this transition had required me to take a significant pay cut, demonstrating that I had prioritized my relationship with Ben over my career advancement. The judge asked Lauren's lawyer if he had any evidence to contradict the documentation I had provided. He didn't. Lauren had never documented her involvement with Ben because she had assumed that being the mother would be enough, and that my role as the working father would count against me. She had no letters from teachers, no medical records, and no photos showing her involvement in Ben's daily life over the past 3 years. The judge took a 30-minute recess to review the evidence. Lauren and her lawyer huddled together, and I could see her crying. She had walked into that courtroom expecting to win full custody, and now she was facing the possibility of having to share Ben 50-50. Her whole plan to weaponize and maintain primary control over Ben was falling apart. When the judge returned, she announced her decision. Based on the evidence presented, she was awarded shared parenting, with Ben spending alternating weeks with each parent. She noted that while Lauren had been Ben's primary caretaker during his early years, the documentation clearly showed that I had been his primary daily caretaker for the past 3.5 years. She said that Ben's best interests would be served by maintaining strong relationships with both parents. Lauren broke down when she heard the decision. All her confidence and satisfaction from earlier in the hearing were gone. Her strategy had backfired completely because they had built their case on assumptions rather than evidence. I felt relief more than triumph. I had protected my relationship with my son, and I had done it by actually being a better father rather than by attacking Lauren's character or manipulating the system. The 3 years of documentation had been worth it, but more importantly, the 3 years of being present in Ben's daily life had been worth it. The practical arrangements took a few weeks to work out. Ben would spend 1 week with me and 1 week with Lauren, switching on Sunday evenings under the shared parenting order. We would alternate major holidays, and both of us could attend his school events and medical appointments. Lauren was responsible for child support during my weeks, since she was now living with Derek and had a higher household income, but the amount was minimal because of the 50-50 split. The transition was harder on Lauren than on Ben. Ben was used to spending time with both of us, and the week-on, week-off schedule actually gave him more focus time with each parent. My life improved significantly after the divorce was finalized. Without Lauren's spending habits, my salary actually stretched much further. Lauren had always been frustrated with our financial situation, but the truth was that she was the reason we struggled to save money. She would buy clothes she wore once, expensive skincare products she never finished, and restaurant meals when we had groceries at home. Living alone during Ben's weeks with Lauren, I was able to save money for the first time in years. I put aside money for Ben's future, for emergencies, for the occasional father-son trip during school breaks. My small apartment felt peaceful instead of tense, and I could focus on being the best father possible during my weeks with Ben. The relationship between Ben and me grew even stronger once we had dedicated time together without the stress of Lauren's unhappiness affecting the household. Lauren eventually adjusted to the new arrangement, though it took several months. Her relationship with her new man didn't provide her with the lifestyle she had wanted for long. My son, Ben, would tell me about her fights with the man, but that was no longer my concern. She never apologized for the things her lawyer said about me in court, but she did acknowledge that I had become a good father to Ben. Looking back on that day in court, I'm proud of how I handled the situation. I could have fought dirty, brought up Lauren's spending problems, her emotional volatility, and her relationship with another man that started before we separated. Instead, I focused on being the best father I could be and documenting that commitment. The evidence spoke for itself. The most satisfying part wasn't proving Lauren wrong. It was protecting my relationship with Ben. He's 11 years old now, and we have a strong bond that nobody can take away. He knows he can count on me to be at his school events, to help with his homework, to be there when he's sick or scared or excited about something new. For any fathers out there going through something similar, my advice is simple. Don't wait until the divorce papers are filed to start being the parent you want to be recognized as in court. Document everything, but more importantly, actually be present in your child's life. Show up consistently, build relationships with teachers and doctors and coaches, and prioritize your child's needs over your own convenience. The lawyer's words still sting when I think about them. Being called a low-level mechanic with a history of disappearing was humiliating, especially in front of a room full of strangers. But the evidence proved that his characterization was wrong, and that's what mattered to the judge. Ben is thriving now, 2 years after the shared parenting arrangement began. He's doing well in school, he has good friends, and he has 2 parents who are both committed to his well-being. Lauren and I will never be friends, but we've learned to co-parent effectively. We communicate about Ben's needs, we both attend his school events, and we've both moved on with our lives. I still work at the auto repair shop, and I'm still proud of the work I do. Lauren may have seen my job as beneath her aspirations, but it's honest work that allows me to provide for my son and maintain the flexibility to be involved in his daily life. The judge didn't care what I did for a living. She cared about whether I was a good father to Ben. That folder of documentation I brought to court represented 3 years of intentional parenting, 3 years of putting Ben's needs first, 3 years of building the foundation for a relationship that would survive divorce and custody battles. It was the best investment I ever made, and Ben was worth every hour of it.